Hello, everyone. Welcome to our first concurrent session of the Symposium. My name is J.B. Hawes. I'm in the Church History and Doctrine Department here at BYU, and it's my pleasure to welcome you to this session. And for those of you in the keynote, what a great start to this conference. I think that signals is going to be a remarkable 2 days, and that momentum will continue in this next session. It's my pleasure to introduce our three presenters for this session, which is entitled Conflicts and Context in 19th Century Missouri. We'll first hear from Professor Alexander L. Baugh, who is a professor and former chair of the Department of Church History and Doctrine at Brigham Young University, a great colleague of mine, and also the founding figure of this very symposium that started 16 years ago, so we owe this to Alex's visionary foresight. He's been a faculty member here at BYU since 1995. He received his BS from Utah State University and his MA and PhD degrees from Brigham Young University. He specializes in researching and writing about the Missouri period of early church history. He's the author, editor, or co-editor of 12 books, including 3 volumes of the document series of the Joseph Smith Papers. In addition, he has published more than 80 historical journal articles, essays, and book chapters. He's a member of the Mormon History Association and the John Whitmer Historical Association, and past editor of Mormon Historical Studies. He is married to the former Susan Johnson, and they are the parents of 5 children and 13 grandchildren. He and his wife reside in Highland, Utah. Please join me in welcoming Professor Baugh.
I just hope I can talk as fast as JB. He's noted for that, and I'll do my best so we can have plenty of time for everyone else. I should just give a little disclaimer. I will be using the term Mormon because, of course, that's a historical term of this period, and hope that is clear. In early July 1833, W.W. Phelps released the 14th issue of the Evening and Morning Star. The contents of the paper appeared much like that in the previous 13 issues. However, on the 5th page of the issue was an article titled Free People of Color, one that certainly caught the attention of pro-slavery Jackson County Gentiles. The article cited 2 state statutes governing slavery, taken directly from the laws of the state of Missouri, published by the Missouri legislature in 1825. Phelps likely accessed the text of the statutes from a copy of the book located in the Jackson County Courthouse, less than a block from his home and printing office in Independence. The first clause Phelps inserted from the volume dealt with free slaves or mulattoes who should come into or settle in Missouri. The statute states that in order to live in Missouri or even enter it, a person of color must produce a certificate containing a state seal showing evidence they were a free citizen. If the individual could not produce a valid certificate, they must leave the state within 30 days. If after 30 days the individual was still in the state, they would be brought to court and may be sentenced to 10 lashes and then forced to leave. The second section inserted by Phelps states that if a person brings a free person of color into the state who does not have the proper certification indicating he or she is free, that person will face prosecution and, if found guilty, would be fined $500. Given Missouri's strict laws governing slavery and free people of color, as well as the attitudes and prejudices of the Missourians toward both groups, Phelps's intention for citing the Missouri statute was meant to advise church leaders in the East and elsewhere not to encourage any free person of color to move or relocate in Missouri. In addition, Phelps probably hoped to demonstrate to the Jackson leaders and citizens that the Mormon leadership in Missouri clearly recognized the legality of slavery and that they had no intentions of interfering with its practice. Given the overall tone of free people of color, one would think that the Jackson citizens could hardly become agitated by quoting directly from the official state statutes. But a careful reading of a short passage in an essay by Phelps immediately following free people of color is revealing. Quote, "Our brethren will find an extract of the law of this state relative to free people of color on another page of this paper. Great care should be taken on this point. In connection with the wonderful events of this age, much is happening towards abolishing slavery and colonizing blacks in Africa." It might have been this brief comment, more so than the text of free people of color, that Jackson citizens had the most issue with. The mere mention of abolishing slavery and colonizing blacks in Africa provided justification to those who were opposed to the Mormons of the need to remove them. Whatever Phelps's good intentions were, they backfired. The community response was swift, so much so that Phelps immediately drafted a statement in an attempt to clarify and explain what he had included in the star, then printed it as an extra in the form of a small handbill. Unfortunately, however, it was too little, too late. Within days, an independent ad hoc citizens committee comprised of some of the leading civil officers and community leaders drafted a document outlining their objections against the Mormons, which they published and circulated throughout the county. Mormons were religious fanatics and the most worthless part of society, they announced. They were inviting free blacks and mulattoes to move to Missouri, had tampered with their slaves, and openly declared that God had given Jackson County to them, and they would eventually have possession of it. In 1881, Alexander Donovan, who acted as legal counsel to the Mormons for 6 years, commented on these accusations. He believed the allegations made about their religious practices and beliefs were merely pretenses, quote, made use of for the purpose of exciting the jealousy of the persons of other religious denominations and the more ignorant portions of the county. The real issues were Mormons came from the northern states, were non-slaveholders, and had anti-slavery sentiments. And two, if the Mormon numbers increased, it could lead to their gaining political control in the county, which would also give them the upper hand, particularly in regards to the institution of slavery. Now, that's what I'm trying to portray here. You can see in just 3 years, just using some estimates, the Mormon population had increased, or at least brought a significant change in the percentages. The ad hoc committee also announced that a public meeting would be held on Saturday, July 20th at the public square in Independence to consider what actions should be taken against the Mormons. Several hundred Jackson citizens turned out, there we go, at the mass meeting, several hundred Jackson citizens turned out at the mass meeting where an official citizens committee was selected to discuss the situation concerning the Mormons and propose a plan of action. This committee deliberated in private, probably for a couple of hours, before issuing their statement to the large crowd who had waited outside the courthouse to learn of their decision. Their report reflected several of the same objections about the Mormons made by the unofficial citizens group a few days earlier. The committee then issued the following ultimatums. Number one, no Mormon should be permitted to settle in the county. Number two, those Mormons who pledged to move out of the county would not be molested and would be given sufficient time to sell their property. Number three, the Evening and Morning Star and the storehouse must cease operation. And number four, the Mormon leadership must use their influence to prevent any further Mormon immigration. After reading the report, a dozen men were chosen to convey the committee's requisitions to the Mormon leaders living in Independence. The meeting then adjourned for 2 hours so the delegation could summon 6 Mormon leaders: Partridge, Phelps, Sidney Gilbert, John Whitmer, John Corll, and Isaac Morley, and to meet with them at the church-owned storehouse located directly west and across the street from the public square. When the men from both parties finally assembled at the store, the Jackson delegation issued their ultimatums. They demanded to have the printing office and the mechanic shops belonging to our people, together with Gilbert and Whitney's store, closed forthwith, wrote Edward Partridge, and the society to leave the county immediately. He continued, we asked for 3 months to consider upon their demands, which was refused. We then asked for 10 days, and we were informed that we'd had 15 minutes were the most that could be granted. Being driven to the necessity of giving an immediate answer, we answered that we could not consent to their demands. Lewis Franklin, the county jailer, replied, I am sorry, the work of destruction will thus commence immediately. Partridge, Corll, and Morley returned to their homes located on the outskirts of town of the Temple property. Gilbert remained at the storehouse, but fearing the worst, Phelps quickly went to his home, gathered whatever documents he considered to be important from the Star offices, and went into hiding. John Whitmer, who assisted Phelps in the printing operations, also went into hiding, and the two may have sequestered together. Within a short time, a large company gathered at the Star offices and began their rampage and destruction. Their main target was the printing equipment on the second floor, where once inside, several men pushed or lifted the press, which weighed several hundred pounds, through probably the outside door to the outside steps, threw it to the ground, and then into the street. Other items from the printing office, such as paper, type, printer tools, and printed materials, were considerably easier to destroy. While the rampage was taking place on the second floor, other mob members ransacked the first floor, which served as Phelps's home, where they destroyed household items, plundered furnishings. In a final act of destruction, a human wrecking crew de-roofed the building, demolished the walls and support structure, turning the building into a heap of rubble. The mob then proceeded to the Gilbert and Whitney store with the intention of wreaking havoc there too, but before they could do so, Gilbert pledged to close the store, cease operations, and box the goods. So they agreed to leave the establishment alone. Satisfied, the attackers backed off and ended their destructive operations. The final target of the mob that day was Bishop Partridge, who, as noted, had returned to his home after he and other Mormon leaders had informed the Citizens Committee's representatives that the Mormons would not comply with their demands. Partridge wrote, "George Simpson and 2 other mobbers entered my house and compelled me to go with them. Soon after leaving my house, I was surrounded by about 50 mobbers who escorted me about a half mile to the public square, where I was surrounded by some 200 or 300 more. Russell Hicks appeared to be the head man of the mob. He told me that his word was the law of the county, and that I must agree to leave the county or suffer consequences. I answered that if I must suffer for my religion, it was no more than others had done before me, that I was not conscious of having injured anyone in the county, therefore I could not consent to leave it. Mr. Hicks then proceeded to strip off my clothes. I strongly protested being stripped naked in the street, when some more humane than the rest interfered, and I was permitted to wear my shirt and pantaloons. Tar and feathers were then brought, and a man by the name of Davis, with the help of another, daubed me with tar from the crown of my head down to my feet, after which feathers were thrown over me. Another Mormon, Charles Allen, was tarred and feathered along with Partridge because he would refuse to denounce his faith. The mob then ended its destructive activities, then called for another meeting to be held 3 days later on July 23rd to allow the Mormon leadership a few days to reconsider their previous decision. On the day of the meeting, hundreds of local citizens gathered once again. Local leaders went to the homes of the Mormon officials and escorted them to the county jail, where they threatened their lives if their demands were not met. Whereupon 2 or 3 of the brethren offered their lives if the rest of the Mormon community could live in peace and safety. This proposal was completely rejected. The only alternative was that all Mormons must agree to leave the county en masse, or all would be put to death. Left without any other option, church leaders agreed to submit to the demands of a signed memorandum of agreement. 9 Mormon leaders, each mentioned by name, and 1/2 of the Mormon population was required to leave the county on or before January 1, the other half by April 1, 1834. Although John Corrill and Sidney Gilbert were permitted to remain as general agents for the church to wind up business of the society. With this agreement in place, for the next couple of months, day-to-day life in Jackson County returned to somewhat normal. Although Missouri church leaders had agreed to leave Jackson, they nonetheless initiated plans to petition state officials with the hope they would intervene and make it possible for them to remain in the county. In initiating these discussions, it was vital that the knowledge of the communications and meetings with these civil authorities be kept from the knowledge of Jackson's citizens and leaders, and to some degree the church members themselves. If word leaked out that the Mormons were negotiating with authorities, it could mean, or it could be seen as trying to back out of their agreement to evacuate the county. Thus, every attempt was made to conduct these discussions with state officials in secret. In late September, Orson Hyde, who had come from Kirtland, and W.W. Phelps went to Jefferson City, where on October 9th, they met personally with Missouri Governor Daniel Dunklin and submitted a formal petition dealing with the events conducted against the Mormons in July, and reassuring the governor that the accusations made against the Mormon people were not true. One request was to allow them to sue for damages for the loss of property, for abuse, and for defamation. 10 days later, on October 19, Dunklin issued a formal response condemning the actions of the Jackson citizens against the Mormons. Quote, "No citizen or numbers of citizens have a right to take the redress of their grievances, whether real or imaginary, into their own hands. Such conduct strikes at the very existence of society and subverts the foundation on which it is based," unquote. The governor indicated that he had been advised by Robert W. Wells, the state attorney general, that the Mormons should secure warrants against the offending parties and pursue litigation in the circuit courts. Emboldened by the support they received from the meeting from the state's chief executive, church leaders announced publicly on October 20th that they would defend their homes and property. At this same time, the Mormon leadership also reached out to David Rice Atchison, William T. Wood, Amos Reeds, and Alexander Donovan, Liberty attorneys requesting their services, and on October 30th, they struck an agreement in which each attorney would be compensated $250 for their work. Of course, we're most familiar with Atchison and Donovan, and both of these men were absolutely incredibly capable attorneys. The announcement of the Mormon intention to remain in Jackson County sparked a swift response by local county regulators. Beginning on October 31st, raiding parties began threatening church members and damaging homes and property, mostly in the Mormon settlements located in Baugh Township, in the western part of the county. Within a week, church leaders submitted to the demands of the anti-Mormon adversaries and agreed to a wholesale evacuation of the county. Within a matter of a few days, members of the Mormon community, most anyway, abandoned their homes and property, taking their livestock, household items, and what food they had ferried across the Missouri River, seeking refuge in temporary homes and shelters in Clay County. During November, Partridge and Phelps worked to assist hundreds of church members resettle in Clay, most of whom were destitute in destitute circumstances. However, now that they were in close proximity to their Liberty attorneys, they were also able to counsel with them in order to consider what course of action to take against their Jackson antagonists. Their efforts were facilitated by a November 24th letter from John F. Ryland, judge of the Fifth Circuit Court of Missouri, to Amos Rees, one of the 4 attorneys employed by the Mormons. Ryland informed Rees that he had been instructed by Dunklin to investigate the recent disturbances taken against the Mormons in Jackson County in order to take steps to punish the guilty. He also went on to say that he would be willing to adjudicate a court of inquiry in independence in behalf of the Mormons. With tacit support coming from Judge Ryland and Governor Dunklin to prosecute the Jackson County offenders, on December 22nd, 1833, the Mormon attorneys filed separate indictments in behalf of Phelps and Partridge at the courthouse in Independence. Phelps charged 25 men with unlawful trespass in connection with the damages to his home and the Evening and Morning Star offices, claiming $3,000 in damages for the printing office and his house, $2,000 for loss of furniture, office equipment, and type, $400 for the press, and $50,000 in personal damages and loss of business. Partridge's complaint included the names of 54 men who participated in the assault that took place against him on the public square. His indictment includes the names of all defendants named by Phelps in his complaint, with the exception of one, Abner Staples. But he added 30 more. Like Phelps, Partridge's suit also gives the figure of $50,000 in personal damages. In the 1830 U.S. federal census, it indicates that 14 of the 55 defendants were slave owners, and that was probably their motivation. But that number was probably higher since many of the defendants were not living in Jackson County when the census was taken 3 years earlier, who may have owned slaves. Both filings were endorsed by the attorneys for the Mormons and certified by Samuel C. Owens, clerk of the Jackson County Court, himself a defendant in both suits. Over the course of the next several weeks, the defendants were subpoenaed by Jacob Gregg, the county sheriff, and ordered to appear in the Jackson County Circuit Court in Independence on February 24, 1834. The defendants employed 7 men to act as their attorneys, 4 of whom were defendants in both cases. Phelps charged the defendants with creating a general noise and disturbance, engaging in a forced entry into the structure, tearing down the interior walls, dismantling the roof and totally demolishing the entire structure, and carrying away and converting to their own use the furniture, printing press, type, and other various apparatus. The defendants named in each suit issued a formal plea, and all pled not guilty. The explanation given by Robert Johnson, one of the leading antagonists, in his plea as to the reason for being not guilty on the charges levied against him by Phelps is typical of all the rest. Significantly, Johnson did not deny his participation in the destruction of the Star offices. Rather, he stated that the structure and property were actually in the possession of Richard McCarty, one of his cohorts, who commanded him to demolish the building for the purpose of repairing and placing new superstructures on the foundation. He further stated the press and the equipment were encumbering the property and that McCarty, the so-called proprietor, commanded him to remove them to a convenient distance and leave them there for the defendant, namely Phelps. Partridge said in his indictment that he was taken by an armed force to the public square where he was in the presence of a large concourse of people. He was thrown to the ground, violently kicked and struck with many blows, and was greatly hurt, bruised, and wounded, after which he was covered with pitch and tar and rolled in feathers. He also mentions the mob with great force and violence rent, tore, and damaged his clothes and wearing apparel, consisting of a coat, hat, waistcoat, breeches, a shirt, and a pair of stockings valued at $50. The complaint states that the incident damaged his reputation and standing in the society, and he requested $50,000 in personal damages. Robert Johnson was also named as a defendant in Partridge's suit, and again, his plea is similar in wording to the other defendants. He states that Partridge made an attempt to assault him first, so in order to defend himself, he did, quote, indignantly treat the said plaintiff by shaking, kicking, striking, throwing him upon the ground, and did a little rend, tear, and damage the clothes of the said plaintiff. As to the tarring and feathering, he said Partridge, quote, became a little covered and besmeared with tar, pitch, and feathers. He did not incur any unnecessary damage or injury on the occasion. Throughout the plea, he declares all his actions were done in self-defense. As preparations for the February Court of Inquiry for Partridge and Phelps progressed, their attorneys found it difficult to secure church members who were willing to serve as witnesses, many of whom feared the possibility of an outbreak of hostilities and personal harm and repercussions by the Jackson citizenry if they were to testify. Recognizing the volatility of the situation, Judge Ryland requested Governor Dunklin attend the hearing, hoping his attendance would help control the situation. Dunklin declined, but responded by appointing Robert W. Wells, the state attorney general, to attend and assist Ryland in the hearing. The governor also authorized David Atchison, one of their attorneys, but who was also a captain in the Clay County Militia and a commander of a uniform company known as the Liberty Blues, to take charge of the 50 men in his company and guard Partridge, Phelps, and their witnesses at the February hearing. He would have had to recuse himself, but he's guarding them there. On February 23rd, the day before the scheduled hearing in Independence, Partridge, Phelps, and a dozen Mormon witnesses met their armed militia guard under the command of Atchison at the Missouri River. They then ferried across and marched about a mile north of Independence, where they spent a cold, snowy night in the open air without tents. The following morning, February 24th, the company made their way to Independence, secured breakfast at a local tavern, and were about to proceed to the hearing in the courthouse when Attorney General Wells and Judge Ryland met them to inform them that a large mob had assembled at the public square who were intent on disrupting the hearing and who had vowed they would not be intimidated by civil law or executive influence. The excitement was of such high pitch that Wells and Ryland feared if they tried to move forward with the hearing, the situation could easily escalate into armed violence, endangering theirs and others' lives. Although Partridge, Phelps, and the witnesses were still willing to hold the court, Wells and Ryland, in private consultation with the attorneys for the Mormons, considered that it would be best to postpone the hearing to a later date and ordered Atchison's company to guard the Mormon plaintiffs and witnesses back to the Clay County. Meanwhile, or I should say between 1834 and 1836, there were at least 4 additional attempts made by the attorneys for the Mormons to move forward the complaints of Partridge and Phelps in the circuit court. In the June 1834 term, the attorneys filed an amended declarations in behalf of the plaintiffs, which corrected some minor errors in their original declarations. In the February 1835 hearing, in order to bolster their case, the defense counsel indicated they would no longer intend to prosecute all of the defendants, and all but 9 of the original 54 were dismissed from the suits. At this time, because they believed they would not receive an impartial hearing if the court was held in Independence, Partridge and Phelps petitioned to be granted a change of venue for the court to be held in Richmond in Ray County, which request was granted, but the change of venue necessitated Partridge pay an additional $200 in court costs. In the March 1836 term of the court, both Phelps and Partridge were in Kirtland, so their attorneys requested their cases be considered in the upcoming July term. In that hearing, a final decision was rendered. The plaintiffs waived a trial by jury and instead agreed to allow the court, namely Judge Ryland, render the decision. He ruled against the remaining 9 defendants, awarding Partridge only 1 cent. In the case of Phelps, Ryland ruled in favor and also awarded him 1 cent, although in the court record it shows that the 1 cent is struck out and $750 is written above it. Whether Phelps was ever actually awarded the money is not known. There's a bit of irony in all of this. Going back to Phelps's Free Persons of Color article published in the Star in July 1833, there is something very significant about this article that it was ignored or completely disregarded by Jackson County citizens, and more specifically those who engaged in any type of maltreatment against the Mormons. After citing the state statutes regarding free people of color, Phelps inserted 2 clauses from the Missouri State Constitution adopted in 1820, both of which deal with the rights of individuals as it pertains to the free exercise of religion. The most important clause is Section 4, quote, that all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own consciences, that no human authority can control or interfere with the rights of conscience, that no person can ever be hurt, molested, or restrained in his religious professions or sentiments if he does not disturb others in their religious worship. Phelps was astutely aware that Missouri Constitution guaranteed one of the most fundamental civil rights, religious freedom, and his intentions clearly underscore that his purpose in citing the state's constitution was to remind their Missouri neighbors of that privilege, which was completely ignored. On the other hand, Jackson citizens saw the actions taken against the Mormons in a much different way. Richard Bushman has written, quote, the Mormon presence in Jackson County tested democracy. The Mormon case illustrated an underlying democratic dilemma. Can a majority in defense of the public good as they see it strip a minority of its rights? The Jackson County citizens believed their procedures were democracy in action, and they came together to prevent a social and political disaster of alarming proportions in their view, and what they believed was acted out in self-defense. But for the Mormons, Jackson County democracy should have also meant the free expression of religious liberty, but came to mean repression and expulsion instead. Sadly, similar scenes of Jackson County democracy would take place against the Mormons again in Clay County in 1836, and again in Caldwell and Davies County in 1838, culminating in the wholesale expulsion of the Mormons from Missouri. Thank you very much.
Thank you, Alex and Bethany and Sherilyn. Wonderful presentations. We have a few minutes for questions. I'm keeping an eye on the text wire, but we can take questions live here, and we have a microphone, so we'll now open it up for questions from the audience. Over here, and wait for your microphone to be delivered for our online audience, and then you can tell us who you'll direct your question to, and we'll have them come up.
Hi, I'm in the middle of reading David McCullough's Harry Truman biography, and so he goes into I don't know who's familiar. Who's read the Harry Truman? Anyway, David McCullough goes into a little bit of depth on what happened in Missouri and the Mormon problem. Anyway, he has kind of an interesting take on Lilburn bogs and just the reason that the Mormons got kicked out, because Harry Truman's ancestors are the ones that settled in Independence and Jackson County, and I was just wondering what your thoughts were, those who spoke today.
You cannot help but like David McCullough. I don't know if you know, he came here to BYU and spoke, and he said, I really appreciate the Y on the mountain in honor of my alma mater, which was Yale. Yeah, that first part of that book, he really goes into Truman's ancestral background and so on and so forth. It's been a long time since I read it, but I thought it was, you know, it was typical David McCullough style narrative kind of history that I thought was really good. So I probably didn't add much to that, but it's...
They felt like he leaves it really open-ended, like that they thought it was the Mormon leadership were responsible for shooting Lilbert Boggs as he was in his home reading. And the other one is, he said the problem with the Mormons is when they got kicked out, they just kept coming back and coming back. But I think he was referring more to the reorganized Church of Jesus Christ of Latter-day Saints.
Yeah, of course, they have a large influence there. Yeah, I have a little different views on the Boggs killing. I don't know if you picked that up. I really believe Porter did it. Let's just kind of, he didn't kill him. It was a buckshot pistol. Wanted to maim him, but not kill him. He was in the area at the time. His in-laws, the Beebes, were there, and I think we can say he was there. He would, of course, deny it. I think I just think it was him. Oh no, Joseph, no, Joseph, no. And that yeah, if you wanted to make that connection with Joseph, Joseph would have not had anything to do with it. Right, so yeah. What do you think, Mark?
Okay, I have a follow-up question on that. So, in the Book of the Law of the Lord, where Joseph Smith is in that section where he's talking about how grateful he is for all of his devoted friends, he talks for a moment about Rockwell, and he says Rockwell was an innocent boy. Wasn't Rockwell like 5 years older than Joseph Smith? But anyway.
I think he was younger, wasn't he?
Or younger, yeah, he's quite a bit younger. I'm sorry. Okay. So, yeah, he says Porter was an innocent boy. And it's not completely clear what he's talking about. Or it seems like he's talking about
his innocence in the shooting.
Yeah. And I think it is significant that this is in the law of the Lord, because for them at that time, and for, a long time after that, until just recently, the law of the Lord is a sacred book. It's a confidential book. It has, the church financial records in it. And it's, so not only is it like, and it has Joseph's personal journal in it. So not only is it like a personal journal, but it's considered Joseph Smith himself considers it a sacred record. Yeah. And obviously it's been being kept private, and he's gushing all of his emotions. And so it seems like, this isn't like he's out in public and he's saying, right, we're not guilty. It's in private, and he's saying he's an innocent boy. And so do you think that's means that Joseph Smith didn't know about what Porter did, or what's your comment on that?
Mark, you're more into the Book of the Law of the Lord than I am. Certainly, I really appreciate that insight. Quite frankly, that might be very well what he's saying. Yeah, he's innocent. He was not the one. So anyway, I probably couldn't respond totally on that, but I think it's something to look at. So, yeah, very good.
We've come to the end of our session. Join with me in thanking the presenters. That was really well done.